When you like, Mr. Garavi.
Before we start, I did find the reference that Professor Stern had asked for at the conclusion of our.
Something for you.
You had asked the question about the decree to which Mr. Kukelchik had referred. It is R165. It is an excerpt from Decree 21, 1989. And in fact, it was slide 5 of my opening statement on the merits from Monday. You'll recall there was a slide that said that excavation can only begin after opening works. Sure. Yes.
If you allow me, President.
Yes.
Good afternoon, sir. We had left off before lunch on the question of advance warning before a decision to revoke is communicated. And I want to move on now to the next topic, which is a related one. Namely, I want to engage with you as to whether or not the decision of the District Mining Authority to revoke Roseman's rights was wise and in conformity with the spirit of the 2002 amendment. As you described the spirit at paragraphs 8 and 9 of your first testimony, if you turn to the paragraph 8 and 9 of your testimony, you discuss the intention of the drafter. And I would like you to consider these two paragraphs. And what I will read you from the Supreme Court decision paragraph at page 25, C36, tab 39, its decision of 2011. And I will read that to you, and I invite you to read it together with me. It starts with, on the English version, it's, let's say, the third paragraph. Finally, the Court of Appeal points out the fact that legal standards do not apply in a vacuum, but within the society, and their main aim is the treatment of social relations in such a way that intervention into rights and interests protected by rights of legal entities.
He's not following.
Okay, but you must have the Slovak
Yeah, we have
version
the
in
Slovak
front of
version,
you.
but he wasn't following where you were. Can you just point out
It's
the
the one page before the last. It starts with the Court of Appeal points out. One page before the last starts with the Court of Appeal points out. It's in reference to the after the June 1st, 2007. You see?
Yeah.
Okay?
Okay.
The paragraph that follows.
So
okay?
starting here.
Again, I'll start again. You're with me. It says, finally, the Court of Appeal points out the fact that legal standards do not apply in a vacuum, but within the society, and their main aim is the treatment of social relations in such a way that intervention into rights and interests protected by rights of legal entities and natural persons occur only in inevitable cases in conformity with public interest and to the smallest extent possible. Then it goes on to say, that is why the administrative body, when issuing an individual administrative act, which undoubtedly causes an intervention into subjective rights of individuals, must evaluate this intervention from all perspectives, mainly concerning its conformity with the public interest and proportionality. And finally, in this case, the public interest was undoubtedly the most possible effective use of the mining area, Jumierska Poloma, however, without any evaluation and comparison of profitability of leaving the plaintiff the mining area in question or assigning to another organization. The decision of the plaintiff was premature, unclear, and insufficiently reasoned. Now, the first question I have, sir, to you is that, have you seen any evaluation of this sort in the file of the district mining prior to January 2005?
Assessment of what? Of public interest, or of legal fact, or of meeting a merit of assessment of what?
In the district mining office, prior to January 2005, of what I have just read to you, whether it was in the public interest, whether it was not premature, whether they were was this the possible, most effective use, comparison of profitability, of leaving the mining area in question to Rosman or assigning it to another? Did you see any such evaluation? I think it's no, but I don't want to suggest that to you. It's yes or no, did you see?
Ja nemám obavy z toho.
I have no concern whether you're going to slip something between the lines to me, but the fact remains that the decision of the Supreme Court, what you are quoting from, is from 2011. I don't know what else we could have done as the mining office to analyze the decision of the judgment of the Supreme Court. The only thing is the legislator had issued an amendment, number 558, when the excavation was never commenced, or when it was suspended for 3 years, the license will cease. So when not only Gemerská Poloma, but additional 20-30 cases were of similar nature. So with regard to lapsing of the period, I hold that there is no body authorized to judge that. It's up to the legislator to enact. So such exclusive site was published for tender for public. So all the shortcomings which are in both the first and second judgment, and which the court ruled against, in the third judgment was no longer contested, and also the consideration was done in the third and final judgment.
Have done that, why you didn't do that? I'm asking you to confirm, basically, that you did not see in the mining district office any report nor any evaluation in terms of proportionality, where the project stood, the intention of the company Rosman to pursue or not, and what were the alternatives. Could you confirm that there was no such evaluation in the records of the district mining office prior to January 3rd, 2005? That's the question. It's yes or no, and I suggest it's no.
Takéto
Such assessment was not part of the appellate file, and the mining office was not obliged to conduct such assessment.
I understand. Do you know that on January 3rd, 2005, at that period of time, Rosman had started works? I'm not saying it's extraction. It had started works as per the protocol of December 8th signed by Mr. Baffy, had signed a contract with the company Siderit, had paid the down payment, and no bills were outstanding. Are you aware of that?
To, či boli vyplatené.
Whether bills were or were not outstanding, I'm not aware of that, but I found about a contract from the appellate file. After 1st of 2005, the company Rosmin was no longer authorized to handle or to dispose of the state excavation area. We no longer interfere into the final decisions made by court.
Okay. I'll move on to
Sorry to interrupt. While we are on this page 25, I read several times, the Court of Appeal points out, finally the Court of Appeal, etc. I understand it's in fact the Supreme Court it speaks of itself, but I would like to have confirmation, yes, from both parties. Yes, okay. Thank you. Sorry.
Pán predseda,
Mr. Chairman, may I have a point of order? Back to your question. May I respond? Supreme Court, as regular appellate court to regional court, but above the Supreme Court there is Constitutional Court as well, even above it.
Okay. Your testimony, as I understood it, was that it is the district mining office who is this exclusive body in charge of the revocation of the mining authorization, right?
oznámiť za...
To notify the cessation of the right to excavate as a result of the time period having lapsed. Yes.
And your testimony is that it never received any instructions from the main mining office, your office, no instructions from the Ministry of Economy, and it did not communicate with these other organs before taking the decision, correct?
Who did not communicate with whom?
Before taking notifying the decision to revoke the rights on January 3rd, 2005, the mining district office did not receive any instructions in relation to this project, to the revocation, and did not consult the main mining office in this relation, correct?
On behalf of the main mining office, I can say no instructions were received by DMO on the matter of Gemerská Poloma. All GMOs received a general instruction how to proceed in all cases, not per any ad hoc case. About communication with the Ministry of Economy, I have absolutely no knowledge. How could I know anything about that?
Was the main mining office, your office, engaged in any action, consultation with other prospective mining companies in relation to this project prior to the revocation notification of January 3rd, 2005?
Nie.
No. But you kept asking if I may be allowed by the panel. You kept asking about communication between Mr. Buffy, Rozložník, and Agaďoš. You never asked, since I have no knowledge of that, you never asked whether I know of somebody else who would have consulted about this issue prior to having issued the January 3, 2005 decision, because my answer would be yes. I personally was approached by Dr. Rozložník the second Thursday and second Friday of May 2004 at the official event of a Slovak-wide celebration of Mining Day on the matter of the Amendment 558 of 2002 in force of January 1, 2002.
It's not my question. My question is, was the main mining office in
Pardon.
contact with other prospective companies interested in
Nie.
this mine?
No.
Again, because it's an important question for you to think again before answering, so that I give you the date. January 3, 2005, revocation by the mining district mining office of our rights. Prior to that, prior to January 3rd, 2005, were other companies in contact with the main mining office in relation to this deposit?
On behalf of the main mining office, Department of Deposit Protection, which I was in charge of at that time, I was not the head of the main mining office. On behalf of myself and my department, I answer no.
Second person in that office, right? You were the deputy head, correct?
Áno,
That is correct.
Who's above you?
zástupca.
Who was above you?
I was deputy Mr. Martin Lutonsky. In the first and second round was the Mr. Martin Durbak.
And who was following your instructions below?
I had my inspectors, Mr. Sikora, Mr. Durbak. At the time when Lutonsky was the head, Mr. Ferenc and Mr. Iring.
Chelar.
Dobre hovoríte.
You said Mr. Dusan Chelar.
Čo s ním?
What about him?
I'm asking you, what is his rank?
Mr. Dusan Chelar at that time at the main mining office did not work. He never worked there. And due to such a time difference, I'm not sure whether he was still at the position of the advisor to Minister of Economy or no, not anymore, because afterwards, after he ceased working as the minister's advisor, he won a tender for district mining office Košice head, but I do not remember the date, just to make sure I do not provide you an incorrect date.
Where is the gentleman today? What is his function and where is he? Do you know?
Where he's working, I have the information from someone told me allegedly in Romania, but I'm not sure in what position, what company, or what location.
Where is he? Which country you said?
Údajne v Rumunsku.
Allegedly, he's in Romania.
Do you know where he was during the January 2005 period?
I think he was at the Košice district mining office, but I could be wrong. But it could be found out easily from his personal file, which is at the main mining office, but I do not recall it on the top of my head.
You didn't try to inquire?
A prečo by som...
Why should I?
If somebody, sir, have you read all the World Bank reports alleging that there is a lot of corruption in the tender process in your country? Are you aware of such reports?
Nie, neviem.
No, I'm not aware.
Are you aware of European commissioned reports alleging that there is lots of corruption in the tender processes in your country?
Nie, neviem.
No, I'm not aware.
Are you aware of reports from the secret services of your country confirming that there are corruption in your country?
Nie.
No, I do not know. I'm not authorized person who would have access to such information.
But I'm not from your country, and I'm aware because you read and watch television, right? This is in the press. It's your country. It talks about tender. Your testimony is you've never heard of allegations of corruption in the tender process in your country.
Mr. Chairman, I think it was clear that witness was simply saying he doesn't have access to Secret Service information.
Well, I'm continuing to tell him that that's not what I was talking about. Reports in the press.
Správy v tlači nie sú...
Press statements are not intelligence agency reporting, it's the journalists reporting.
Môžem, pán predseda, k tejto otázke?
May I elaborate on this question, Mr. Chairman?
Mr. Chairman, I'm not Mr. Chairman.
One with your questions.
Thank you. Sir, can I turn to your second witness statement for a second? At paragraph 1, you submitted a first witness statement. in the counter memorial, it's a legal document submitted by Slovakia representatives. It attached your first witness statement. Then in the second submission of Slovak Republic, we found your second witness testimony. And it says in paragraph 1, on June 29th, 2015, I prepared my first witness statement, the accuracy of which I again confirm. Then you say, I have read the statements and claimants' reply dated September 29th, 2015, and I have prepared the second witness statement to react to what are, in my opinion, false and misleading statements in the reply concerning delays in obtaining a new authorization of mining activities, which were allegedly attributable to the bureaucratic process before Slovak authorities. And I have strictly no question in relation to the paragraphs that follow your witness statement, because you address bureaucratic issues in response to the reply memorial. The question I have in this regard is, if you turn precisely to my memorial, it's at tab 48. It's the reply memorial to which you react in your second witness statement. And at paragraph 464 of
English
it,
version.
Yeah, we do.
and this, what I'm going to read to you, is not a factual document. It's a legal position of counsel, us, of Belmont, in this arbitration. So this is what we say. And we say at paragraph 464 that days before appointment of the selection committee for the tender that followed the revocation of our rights, the tenders had already been ranked. Tender applicants had been ranked. Indeed, we say on April 11th, 2005, Mr. Cheller disclosed in an email to Mr. Keller being from the company Mondo, the name of the entities that had so far bid for the project, with specific indications as to which bids were more interesting to the state. And my question to you is, how come you choose to react in your second witness statement in relation to bureaucratic issues, but not on such an important allegation?
I'm not aware or statement or meeting of Mr. Chelar with Mr. Keller. And in a way, from the viewpoint of legal procedure for tender is completely irrelevant.
Okay, I understand.
Pán inžinier Čelar,
Mr. Chilla, in no case, in no way, regardless of what position he was at, could not have impacted or in any way influenced the tender, and I'm convinced that never happened. And I have an evidence of this, not only a statement of someone, because due to the initiative of Rosmin, criminal police had investigated thoroughly, having questioned the entire tender commission, have questioned all of the employees who were involved from the mining office, and despite the fact that I was not in my office at that time, I was also providing testimony to criminal police. So I hold, if something like that nature were to occur, the criminal police would have investigated and discovered it, and would have initiated indictment and criminal proceedings against someone. If you have such information, please disclose this information here.
We can. It's an invitation to disclose the documents, but I'll stay with with my question. Is you read our reply memorial? That's why you write in the paragraph 1 of your second witness statement that you have things to criticize about our memorial. Did you read that statement I just read you about the alleged irregularities in the bid procedure, Mr. Cheller in communication with tenders? Did you read that at the time when you wrote your second witness statement?
Pri,
With my second testimony, or witness testimony, I was not aware of this information, so thus I have not responded to it. And the claims about the bureaucratic procedure of state bodies in Slovakia, as they relate to issuing permits to mining activities, completely irrelevant to action or inaction of Mr. Keller. Because in my second witness statement, I know very well what I wrote and what I've signed. Clearly, I point to the fact how administrative proceedings were handled in the matter of issuing permits for Rosmin for mining activities after the expiry of the first mining proceedings, and there was no influence on the selection procedure, and we have evidence in written documents how the commission had proceeded, how organization of Rosmin had proceeded as well.
You checked. What we said is true. Have you talked to Mr. Cheller about whether or not he was in contact with other bidders during the selection process in 2002?
Nie.
2005? No.
No.
Okay. Sir, do you have your files in relation to this dispute project from the years 2005, 2006, 2007, or did you classify them?
alebo sú čo?
It's not working.
Sorry, what do you mean by did you classify them?
No, do you have your files, your papers, your emails from the year 2005, 2006, 2007 in relation to this file?
Neviem, o čom hovoríte.
I'm not sure what you're talking about.
Sir, you have a costume, you have an office, you have an important position, you have documents, you have a computer, correct? You have a computer in your office? You have a computer in your office?
V kancelárii?
Yes, in the office I do.
Do you receive emails? Do you send emails?
Áno.
Yes.
Do you have your emails from the year 2005, 2006, 2007 in relation to this file? Communications you may have had regarding this file?
With myself, you mean?
No, I guess you don't communicate with yourself, you communicate with others, but that was probably your question. Yes, do you have the emails that are sent to you and the emails that you send to others in relation to this file for the years 2005, 2006?
I don't remember emailing anything like that to anyone.
Okay, do you keep in general your emails from if you wanted to find an email from your file, any file of 2005, could you have access to it?
When they pertain to official business or official files, they are included in a file, and the original copies and photocopies, in order to avoid printing problems or accidental deletion, they are kept in archive, but I do not keep older emails. All official documents, including emails, are included in file, in any relevant file. So if there are emails, they are included in a file.
The files aside, the emails, does somebody come and delete them, or they remain in the computer system? Do you know?
Could I kindly ask this respected tribunal to take into consideration the fact that the electronic mail, according to Slovak legislation, has a principle which still applies. Every citizen and every legal entity, including foreign legal entities, are authorized to apply through email any application to any official body in Slovakia. When they do not add it within 3 days in writing, it is not considered as done. recently we have been conducting electronization of state administration. Electronic signature was introduced. Those who do have electronic signature authorized, they no longer have to supply an additional hard copy with the emails within the 3-day deadline. So I do not completely understand the question whether we archive, our main office archives emails from 2005, 6, or 7, because I'm neither an engineer. I have no obligation in this regard. My obligation is to archive files as such. And if in case electronic email was part of any official file, it is then included in the file.
Vrátane pošta.
And this also includes the recipient, the sender, all the other information which is required. Whether it is in the IT system or not, I would need to verify that. I don't think it's unfeasible.
Could you, sir, go to tab 49? And tab 49, I will start with, yes, wait. It's tab 46 actually, and we will start with the exhibit number C0357, dated 13th of December 2004, for Mondo Minerals, to Mr. Cheller, C0357. Sir, this is an email from a company. Have you heard of the company Mondo Minerals?
Áno.
Yes.
Okay. So you have a official from Mondo Minerals by the name of Keller, who writes to Mr. Cheller. And Mr. Cheller, we submit, works in your office, correct?
Pracoval.
He was working. He's no longer working there.
Okay. From what was the period of time when he was working there?
To, že pracoval, je istá.
Well, I'm sure he was working in a certain period, but I don't know when, because he was working at a district mining office in Košice, later in Spišská Nová Ves. Then he was working in the Ministry of Economy. He returned back to the district mining office in Košice. I don't know. I'm afraid I would give you a wrong answer. What was the specific period when he worked at the district mining office in Košice?
Well,
Malo by to byť od roku.
I suppose this was from 2004 on. I'm not sure about the month.
do you know why the Mondo Minerals is in discussion with someone from the, let's say Mr. Cello was at the district mining office and not at the main mining office at that time, in relation to a deposit that had not yet been revoked?
Neviem.
I don't know. Even though this email is in English, I see it for the first time here.
It's the first time. You've never seen it
I
because
know.
nobody has brought it to your attention. When you address in your second witness statement stamps for application permits, but you have emails of this sort showing contact between mining companies interested to take our rights, which were not revoked at the time, and you were not shown this email. Is that my understanding? You didn't see this email before. It's the first time.
Áno.
Who was supposed to notify me about this email?
To je oficiálna dokumentácia
Yes.
úradu?
Or you read yourself. You said I read the.
Is this the official documentation of the office?
You said in your second witness statement you read the reply memorial, and in our reply memorial we address this. We also submit this. But fine, your testimony is that you never seen this. Correct?
Mohol by som.
Could I see a Slovak translation of this document?
Back to translation, we don't have the luxury of providing it to you right now, but I can read it to you, and the people can translate, the translators, and counsel for the government is here to correct me if I say something that is not correct. Mondo Minerals, Mr. Keller, emails Mr. Cheller on 13th of December 2004. This is Exhibit C357. And says, thank you for your kind hospitality during my visit to the Jemerska Poloma Talk mine, which is our project at the time, last weekend, and for arranging the meeting with the Deputy Prime Minister of the Slovak Republic and the Ministry for Economy, the Honorable Mr. Roscoe. I hope that the attached PowerPoint presentation of Mondo Minerals will help to illustrate the business and activities of Mondo Minerals. If you have any questions, please let me know. Were you informed, forget about this email, were you informed that Mr. Cheller was in discussions with Mondo Minerals at that period of time, first half of December 2004, as well as the Minister for Economy of your country?
Nie, nevedel.
No, I was not aware of that.
Does it surprise you?
Že som to nevedel.
The fact that I didn't know, or the fact that there was a discussion?
No.
Mne minister hospodárstva
The Minister of Economy does not inform me about whom he is meeting, and Mr. Chelar, well, I doubt he was organizing it in a way as to inform the broad public. For example, I see this email for the first time, and I do not know on the basis of which they have met and what was the subject of the discussion. The fact that Minister Ruskov was there, I can only say that the minister knew what he was doing.
But maybe you can explain how it works in your country, because this I really don't know. You have Mr. Cheller, which is at the lower district office, in communication regarding a deposit with the minister. And how come you're not involved in that time? Maybe you have your uniform, you exist as well. You have the right to know, you have the right to participate. Why not you? You exist as well.
No, už keď
Well, now that we are going into such a detail, first of all, in December 2004, I was the head of a department at the main mining office. Mr. Chelar was not subordinate to me, but to the chairman of the mining office. He wasn't responsible to me. He was not bound to reply to me or to respond to me. He was not my subordinate. Never in an official documentation have I seen this information. Otherwise, I would be informed about it.
And how come during the challenge procedures that were ongoing in 2006, 2007, 2008, 2009, 2010, 2011, 2012, including 2 decisions in relation to the talc project taken by yourself as the head of the main mining office, you did not speak to the ministers at the time that were involved, to Mr. Cheller, with all these allegations of corruption, irregularities? Didn't you miss something in carrying out due diligence in the fact-finding process? You didn't do your job correctly then, did you?
No to je váš názor.
Well, that is your opinion. My opinion is that Mr. Chelar was not authorized to act in this way, and I'm not going to talk on behalf of Mr. Chelar nor on behalf of the minister. The situation was as follows. The document that I see here, the file has not been listed. This document has not been added to official file. Regarding my position as the chairman of the main mining office, I can assure you that I was responsibly following this file. In case of the court decisions, I was very careful about it, with a special emphasis on the fact that all the requirements of the court would be complied with. Regarding my discussions with various ministers on regarding the issue talk Gemerská Poloma, we had following talks. Only once was I involved. despite of denial from the Rosmin company. Only once was I involved at a meeting at the Ministry of Economy with Minister Rusko. I do not know the specific date. I know this was in 2005 when Mr. Durbak was the chairman of the main mining office. He took me with him as the responsible head of the department for protection of deposits. We were involved in a meeting between the Ministry of Economy and the reception or the meeting with the representatives of Rosmin. This was the only meeting I was taking part in. Dr. Rozložník said I couldn't understand a thing because the meeting was in German. There was no simultaneous interpreting, or it was in English perhaps. There was another discussion I had with the minister. This was with Minister Malcharek, who appointed me as the head of the main mining office. Mr. Malcharek met me with the presence of representatives of the chambers of miners and expert advisors, where he clearly stated his full support of the main mining office in respect to this file. And he stood behind all the decisions we've issued up to that point in time. Other meetings we had was with the following minister, Mr. Jahnátek. Always after we had a court proceedings, I always informed and briefed the minister on the status quo in this file.
Okay, now the email is here. You know the information, and you seem to have a very firm idea as what is regular, what is official, what is acceptable or not. Is this an acceptable procedure that before the official revocation, you were insisting legally our rights to Rosmin were revoked only in January 3rd, 2005. Is it an appropriate procedure that before that revocation, the district mining office, with the implication of the minister, shows our TAC project to other investors? Is that regular procedure?
We object to that, Mr. Chairman. That has not been established. You members of the tribunal will recall it excluded a document that the claimants alleged supported this fact, but that is not established from this document, nor has it been established otherwise.
I'm just working on this document. It's C357, and there is an email.
The document is not from anyone who works for the government.
It's from Mr. Keller to Mr. Cheller. What are you following, sir? It's C0357. It's not the first one, it's the second one. Maybe you're confused. I confused you because there were two. See?
This is another document from Mr. Keller.
It's to Mr. Keller. Okay? From Mr. Keller to Mr. Cheller. It's the second one I'm talking about, hence the confusion. So if you allow me, I'll proceed.
I just want to be clear.
It's C0357. It's the second document in the tab that you have, 46.
The document that I have shows it's from Mr. Keller,
Yes.
who is not an employee of the government.
No, of course, but it is from Mondo Minerals to Mr. Cheller, from the mining office.
I understand, but the objection is that the suggestion was made that some correspondence came from the government. None of these documents show anything coming from the government.
Well, it is forwarded afterwards, isn't it? But anyways, assume that is it a normal procedure, acceptable procedure for the district mining office to be in contact and show the deposit, our deposit, to other investors before the revocation without informing us?
Neviem, aké...
I don't know which district office you talk about. The respective or responsible authority was the Spišská Nová Ves DMO. Dušan Čelar was not responsible in any way for this case, for this file, and information where he was, where the minister was, I'm not competent to comment on that.
Do you know who won the tender?
Kto vyhral tender?
Who won the tender? Is this the question?
After our rights were revoked, our rights were given to another company.
Samozrejme, že viem.
Of course I know.
Which company?
RV Agency.
RV Agency Rožňava.
Is that a multinational company? No.
Prečo by mala byť?
Why should it be?
I'm asking you.
V Slovenskej republike platí podmienka,
In the Slovak Republic, there is a condition that whoever wants to take part in a tender needs to comply with three conditions. RV agency, any other agency, they complied with these conditions, and that's why they were part of the tender.
Did it have a long track history as a company in Slovakia before it won the tender?
okrem jednej
With the exception of one organization in the tender, all the remaining five were younger than 1 month in terms of their mining permit, which was a condition for the tender.
Sorry, just to interrupt, just to say that in an answer to a previous question by you, the witness says, my opinion is that Mr. Celler was not authorized to act in this way.
Yes.
And I'm not going to talk on behalf of Mr. Celler. So that's something that is already an answer to your questions afterwards, I think. Anyway, I wanted to...
Yes, but I moved the subject.
I know, but...
What can I do?
Nothing. Just putting that in the record.
Thank you very much. We appreciate that, Mr. President. Yes, I noted that. Thank you.
You were asking and asking.
Yes. But I moved finally to the economic agency. Economic agency. How many people did it employ when it was awarded the tender? Do you know?
Neviem.
I don't know.
One person? Or not even? Nobody? It was a set-up company, sir.
Ja osobne si myslím, že to nie je pravda.
I'm personally convinced this is not true, whatever you allege. If members of the tribunal permit, the minimum was 2 people.
I'm asking questions. How many? Do you know who was the...
Ukázal si, že jedna.
Yeah.
You showed 1 person.
No, I'm asking you whether you know anything about economic agency. What do you know about the economic agency at the time it won the tender?
O Economy Agency vie,
With respect to economy agency, I'm not informed about them from the tender. Let me elaborate on that. Let me explain in order to avoid a wrong interpretation of my statement. All the information that I will now state were delivered to me from the regional prosecution office in Košice, which bound me by their decision to verify the completeness and also the full content of the technical documentation that was provided for the tender procedure. In the tender procedure, with exception of 1 company, all other companies were newly established companies, including Mondo Minerals. All the companies in the tender procedure complied with the condition of having a branch office in Slovakia. They were registered in the legal register of Slovak Republic, and they also had the mining permit as the expert precondition for acting in this field. As a follow-up, they've submitted their bids, their projects, which were assessed. They were assessed by an independent expert panel. This panel recommended an order, or they ordered them according to the quality of their projects, and the DMO had no other possibility other than to approve the recommended order issued by the panel. after assessing the quality of these projects, which was a duty given to me by the Regional Prosecution Office, we, as the main mining office, who was overseeing the whole procedure and who is responsible for the minerals in Slovakia, we've stated that all the involved contenders complied with the tender requirements, and as regards the individual qualities and the expert quality of the proposed bids and projects, with the exception of the RV agency projects, none of them complied with all the preconditions as they were stipulated as mandatory conditions in the tender instruction.
Mondo Minerals, incorporated in Bratislava, is owned by which company? By Mondo Minerals. Economy Agency, registered in Slovakia, is owned by the wife of Mr. Korech, who is an accountant. What is the experience of this lady? What is the backup of this lady? What is the credentials of this lady? Who is the team? Where are they going to get find money? And remember the 2002 amendment, paragraph 8 and 9 of your witness statement, the philosophy, you revoke people to give it in the hands of people that have the means, the intention, the experience, I would say, necessarily to move this forward. Did Economy Agency have that experience, knowledge, intention, means?
Podľa predloženého
In accordance to the submitted design project or bid, they did, because they've declared so and they've met all the conditions of the tender terms of reference. An independent panel, which cannot be impacted because there are varied members, unknown until the very last moment. Not even the DMO knows the names of the members of the panels. And they assess not a company, but a project submitted as part of the bid.
To my previous questions for Mr. Cheller, you suggested that had this happened, it would have been irregular from him to interfere in this way prior to the revocation of our rights. Then you testified that you didn't speak to Mr. Cheller. Then Mr. Baffy, who has signed the protocols, was involved. You didn't speak to him as to the meetings he had with us, his understanding of the amendment of the law. Now, on Economic Agency, you say that there was an important amendment, and we have on the record that this is a newly set up company by nobodies that have no established means and no experience. And the conclusion I draw from that, sir, isn't the whole procedure tainted? Does it stink? Isn't it in conformity with the international reports that I mentioned from the World Bank? It's bad, isn't it?
I'll try and answer this. I didn't say anything about Mr. Cheller because he was not authorized to handle these things as they relate to this email. You've kept asking me about Mr. Buffy, whether I've talked to him about this, but you have no interest to know that I've myself instructed Mr. Rozložník to what risk he's exposing himself to. With regard to RV agency and others, I did inform this tribunal that I issued written record. If it's not on file, I can submit it. That the prosecution office instructed me to verify all the design projects, all the bids submitted, whether they've met all the particulars. That is why I'm aware of these projects. I've had to become familiar with them into much detail because of this instruction from the prosecution office, and they are still on file in a sealed safe. And other issues with regard to if I'm claim I did not speak to Buffy or RV agency, had no authorized or professionally apt people, professionally capable people did have to be in the company once they have met all the particulars of the tender terms of reference. The same issue, the permit was issued to Mondo Minerals, just like to Rosmin, who in May in 1997 received a mining permit, and consequently the my excavation area was transferred 1 month later from state company to the Rosmin company. So same conditions do apply to one and do not apply to another entity. I am a state official who is an employee of the government. I can only do what the Slovak law enables me to do. So on the day of the tender, once they open the bids, the panel members of the selection committee, it is in that moment that it becomes what was submitted as part of the individual bids, but who made the bid is only assessed as part of the selection procedure later, part of the tender. Every bidder has to submit all the particulars, with including the permits, including the aptitude or professional experience. Now, as long as you ask me about the ARB agency, I only remember 3 projects of theirs. For Mondo project was Mr. Shirila, for ARB agency Mr. Chorej. They both are holders of a valid certificate of professional aptitude for such projects, obtained by state exam, and they have an official government exam about the professional expertise.
If it's as simple as that, as to pass an exam and then award, for example, a monkey to win a tender and say, I have an exam, I mean, come on, that's not going to work. And the question I have for you is that now you know, you said you didn't read that section of our reply memo. Assume with me that I would be able to demonstrate to you, convince you, that during the tender process, there was somebody from the district mining office opening the tenders before the selection committee was in place, but after the tenders applications were submitted, opening them and commenting to one of the tender applicants. Would that taint the procedure? Would you conclude that, oof, that thing smells? Would that convince you?
I'm curious when you submit evidence to this respect, because I claim that that is not possible. If in official mail, in official archive, bids would be opened, envelopes opened before the tender procedure, that is not possible. The way the system is set up, it makes sure that is not possible.
It's not possible because it's irregular, it's not professional, etc. But if that would happen by luck or by some kind of magic, it would not be regular, right? It would taint the procedure, correct?
Ja na zázrak
I do not believe in miracles.
You don't believe in what?
I do not believe in miracles. No miracle could have occurred.
Assume it happens, it would be irregular. It's irregular, I think you can admit that. If somebody opens the tenders and communicates before the committee is put in place with the applicants, it's irregular. Come on, you can give me something. You don't want to give me that?
Implied in the
answer,
witness's
yes.
answer.
Ďakujem.
Then
Thank you.
the economy agency, do you think, now that I put to you that it is owned by an accountant, and you know what happened to economic agency, namely it gave its shares to another company afterwards, did that selection process of economy agency meet the spirit of the 2002 amendment as you describe it? Was a company that intended with serious means to extract minerals selected?
Ja určite nebudem.
I will definitely not speak on behalf of the economic agency. I'll just share the facts which exist, and these facts are unquestionable. A lawfully stipulated deadline after tender procedure went underway, the deposit was opened, prepared, and exploited within 3 years' time. These are arguments which are documented and undisputable. Whether the economic agency had such or such intentions or wanted to do this or that, that is not up to the powers of mining office to view or judge that or to assess the intentions of some kind of individuals.
Economic agency was selected over others? Do you know what were the advantages the economic agency had over other applicants?
I did say some moments ago, and let me repeat that. Economic agency was selected by an independent selection committee composed of 7 individuals. The entire matter, except for the prosecution office, was also investigated by criminal police. Based on the prosecution office order, I was verifying as the main and head of main mining office all the particulars of all the projects submitted as part of the bids. The only project part of the bid which included all particulars required by the tender. I'm only talking about particulars and details the project individual to proposing was supposed to submit was Mr. Chorey, Economic Agency. It was the only one who met all the particulars because all the other bids were missing some particulars of such or other nature. It is all documented. It is all written records made of, and the written record is made and submitted to the Košice District Regional Prosecution Office, who then returned the entire file to both the district and main mining office.
Conclude that from your assessment at the time, when you looked at this question as to whether or not the economic agency really deserved to win, the conclusion was that it won by default because others were de facto eliminated. Is that the conclusion you reached? Is that what you just said as well? Mainly others didn't comply, and only economic agency was left, and then we awarded that to economic agency.
Nie, nie możecie si...
No, you may not interpret these words in this way. I did say this clearly. The order was established by the selection commission, not the district nor the main mining office. We only assessed the formal and the legal procedural side of the entire tender.
Could you go to R0194, which is in the pochette that has been distributed to you? Yes, it should be the second or third document, professors. R0194. It's report of the advisory committee of the chairman of the mining office. It's you, a very respectable head of that department. Your name is on the top of the document. You assess this situation, and at the bottom of the page, you have the following results. You say in the proposal of organization Siderit, there were some things missing. You say that New Slovakia were also things missing. Then you say economic agency, bravo, it met the legal regulations. Fourth, the other one had things missing. Mondo Minerals, it had things missing, and in parentheses you say 7 counterparts of map of surface situation are missing in the proposal, which I understand to mean that it missed simply 7 photocopies in that application. Correct?
I'll answer very simply. This is not a report to me as the head. I was not a head of the main office at the time. It says present Kukelchik, head of department. And the commission verified all the bids and just stated what was missing in individual bids. Proposed that the designation to excavation area is not only missing 7 copies, it's legal requirements applicable by law, lawful requirements in the Slovak Republic, and there is a secondary law standard requiring certain particulars, and these were missing by Mondo Minerals.
Thank you for the clarification. I understand that in the second page, it said basically, according to the 6 that indicated, that means I understand based on the foregoing, 6 proposals, only 1 qualified, and that's economic agency, because others had bits and pieces missing, including, as far as Mondo Minerals is concerned, 7 mere photocopies of a document. Is that my understanding correct? That everybody was eliminated, and because of some missing documents in the application.
Nie, to nie jest prawda.
No, that is not true.
To nie je pravda.
That is not true.
Je dokument,
This is a document. We have verified formula particulars for regional prosecution office. This is not a document based on which the selection commission was deciding about the order of bids. In my knowledge, I hope I'm not wrong, the commission did not exclude anyone due to the problems in projects or because of missing 7 copies. 7 copies is a map of surface area. I'm not sure if you're aware of what it is. It is one of the most significant mapping documents there is.
I was going to raise this issue as well. It's not just that the photocopies were missing, it was the map itself was missing.
Okay, but he had an opportunity to respond.
Yes, but when there are premises in your question that have
No,
not
I
been
read.
established, it's fair for me to object and point that
No, it's
out.
not, because I said 7 counterparts. Is my understanding correct? Do you have on the record any proof that somebody tried to get in touch with any of the 5 companies to try to draw their attention to the fact that somebody was missing? Or is that not the problem of the selection committee? Sir, you have 5. This is a 2002 amendment. It's very important. You kick out somebody. You put in a tender procedure. 6 applicants. 5 of them are eliminated because they don't have the papers, documents, they have stuff missing, and 1 remains.
We have not thrown away anyone from the deposit. One thing. Second thing is, selection commission did not exclude any bid within tender due to some formalities or substantive particulars missing. The commission judged all the bids submitted, and they have made a final decision, and the responsibility for that decision is only held by the commission, composed of 7 members.
Okay, did you see any evaluation of any selection committee at the time of selection or immediately thereafter as to whether the economic agency had the requirements in terms of experience, financial means, intention to meet the objectives of the 2002 amendment? Because after all, you kick somebody out. You don't want to bring somebody that is worse or the same. Have you seen any evaluation?
All this information is included in the project, how the bidder intends to go ahead with this project, technically, economically, including financial cost. That, whether the development after the tender had occurred, cannot impact the fact that there was a legitimate procedure that cannot be impacted by neither district or the main mining office. The fact that the company Rosmin held for 3 years permit and only had excavated 30 meters. They had opened, the consequent company afterwards had opened the deposit and they had started excavating, dobivat. So is this a progress or is it not?
Excuse me, I don't know if it was a translation issue or a court reporter issue, but it said Rosman held for 3 years. I think he said 7.5 years.
7.5. Maybe we can clarify with the witness.
But listen, I'm not talking about...
7,5 roka.
7.5 years.
I assume with you that Roseman is the worst company in the world. Forget about Roseman, okay? You want to bring somebody that is new, okay? Okay, what did you see in the file that assured you that economic agency had the money even to go forward? Did you see anything in the file?
I saw in the project technical design of opening, preparation, and excavation, dobivanie. I seen in the technical project the procedure, method of excavation. I saw technical and economic parameters, geological parameters. I saw in the bid project financial side of the whole matter. I saw in the project something I would call, I'm no expert for economy, but it's a financial guarantee, a certificate obtained, a pledge of monies provided, of funding provided, which was calculated based on the technical design proposed. The only thing I can say about this is the technical projects of the remaining bidders equally dealt with technical designs of opening preparation. They attempted all to include which was required by the district mining office as per tender terms of reference, which includes all the conditions to be met by any bidder. So, consequently, when we placed the question, so that when I seen the project, did I know that this was the chosen company? I hold that it would be a pure speculation. I was interested not as a lawyer, but as a technician, only in fact. The deposit was opened and excavation began. Everything else became irrelevant. From the viewpoint of Slovak Republic and protection of its mining wealth, of its mineral wealth and excavation thereof.
I'm going to engage with you a little bit further because I don't want us to go around the circle. I want to again be very blunt with you. In 2002 amendment, you described a philosophy. You want to kick out losers or those that have no intention or no means. I think we agree on that. You kick us out. You treat us. You claim today that we are losers, didn't have financial means, and we were sitting on that thing idle. Then you tender and you give it to economic agency. And I put it again to you. If that amendment is intended to be applied seriously, to the point to have people kicked out and appoint new ones, then you would expect to see something, financial analysis of the company there. Not by you necessarily, but by someone in charge of allocating the tender. And my understanding on the file and listening to you to say that there is zero out there to assess the economic capacity and of this economy agency to go forward. Am I correct to conclude there is nothing on the financial capacity of economy agency?
Pred chvíľou som uviedol,
A moment ago, I've stated that from the aforementioned activity, I found that there was a pledge. Forgive me the vulgar word. I don't know what exact document it's now included in the bid about financial guarantees, just like with all the other bids. I did not ask for the place of being placed as a member of the selection commission. I was only dealing with all the particulars met. And the member of the commission, each member of the commissions vote with their best conscience and knowledge whom they are going to vote in favor of. Whether they did or did not have the bidders' particulars met or the winners of the tender, everything, the result being at the Mondo Minerals equally to other bidders were also 1 or 2 man operations. I can't even list all the other bidders from top of my head, but it was VSK. They only had the technical potential themselves. Now, when you refer to how bad the organization is or how many people they had, how many people had Rosmin? 3 people. How many of them conducted mining activities? Not one. So if you were to be honest, I admire you because you are a very smart lawyer, but I don't think you're going to be able to push me to a speculation into trying to respond to we thought or hearsay or this. Mining officials do not think, do not consider, do not speculate. They act as they are required by law. That's what we have done. We were reviewed by 3 different agencies, both district, both main. There were 3 reviews by courts done. Why was that not appealed against?
And 2, you're bigger than me. I wouldn't dare push you. I'm trying to just find out whether or not there was some financial analysis. You saw some concrete financial documents supporting this newly established company owned by an accountant. And I understand from your answer is that you saw zero, nothing. And in that relation, I would like to...
That is not true.
He at least said the opposite.
36, what did you see then? What did you exactly see in terms of financial capacity of economic agency? Concretely, not blah, blah, I saw a pledge of this thing. What did you see? If you don't remember, say you don't remember. But concretely, what did you see?
Ja som už povedal,
I did say this a moment ago, maybe 5 times, that a document about financial pledge of the project was included in the project as part of the bid. What document exactly it was, I no longer remember, and I would definitely not tell you exactly because I'm no economist. I am not familiar with banking rules. What exactly was that pledge document, financial backing, because the selection commission, not only with that particular tender, they had sustained with any bidders appropriate pledges or banking or funding documents proving their own funding potential. And it's 100% it was included in the bid. What exact form of financial pledge it was, I'm unable to define to you exactly. Definitely it was something the commission found acceptable. Not the DMO or MMO, the selection commission.
On this, I'll proceed to tab 36. Tab 36 is C268. You have the reaction of Mondo Minerals to the tender that warranted a letter from Mondo's attorney addressed to the head office of the district mining. It's dated May 18th, 2005. First question is, when did you see this document for the first time?
predpokladám, že keď je to
I suppose when it's from May 2005, since I'm CC'd to the main mining office, I suppose that I have seen this document.
Can I walk you to 1, 2, 3, 4, 5, 6 paragraph, 6th paragraph after item 7, new close, Slovakia SRO. And it's item 1. It says the company agency SR consists of one person. It was established on April 31st, 2004 by a natural person, Ms. Koreyova. The execution of the mining activity and of activity executed with mining method was inscribed in the object of activity of the company that handles also with the brokering, trade activity, and accountancy only on March 31st, 2005. Is that true first? Did you verify whether the company's purpose was brokering, trade activity, and accountancy? Is that true? Did you verify that? Brokerage is not good, huh?
najprv by som
I first would like to see the paragraph because your colleague is not keeping up to show it to me. Let me just read it first.
And then I continue while you're reading. It says, given that this is a company that does not have sufficient capital and financial means necessary for the mining of the deposit, it was selected by the committee as first, despite the fact that it did not demonstrate financial means necessary for the mining of the deposit. That is estimated at approximately 500 million koron. Document with the company submitted in connection to this into the selection procedure labeled as indicative credit commitment from the branch office of the Tatra Bank is not in any case a document confirming financial security, since this is a non-binding loan promise by which the bank itself bound only to negotiations with this company about possible future provision of a loan and its conditions, while the bank in the document emphasized that any obligations do not arise from this activity this indicative credit commitment towards this company. Have you read it now?
Áno.
Yes.
And I have, is that, did you verify whether this gentleman is telling the truth, that the company that won, Economic Agency, is a company engaged in the brokering, trade activity, and accountancy only? Did you verify, is that true?
Táto sťažnosť je
This is addressed to the district mining office. We've only verified the consequent objection. So I'm not sure whether this initial objection was because we did not have jurisdiction in the first instance. But with the
Verify or not, forget about this letter now. Did you verify or not that the winning company was engaged or not only in trade activity or brokerage and accountancy only on March 31st, 2005? Did you verify that information? Is it true?
within the appellate proceedings, I'm sure we have verified this fact, but not from the viewpoint of assessing a potential change of order about which only the selection commission could decide, because neither district nor main mine office have authority by law to enter in changing the order of bids.
Is it true that that company at the time was engaged in brokering, trade activity, and accountancy? Is it true?
And the excerpt from the business register is part of the file. It is possible, but since they were bidding in a tender, they had to be holders of mining activities.
But they had brokering, it was a
No.
brokering firm when it applied, correct? Brokering, trade activity, and accountancy. And if that's the case, then how does that on its face is compatible with the 2002 amendment where you're trying to get out of the intermediary systems, those that are in the middleman? How is that compatible? It's not, is it?
Kde novela z 2002 hovorí,
Where does the 2002 amendment say that we're trying to get rid of some intermediaries?
voľný výklad
Your free interpretation of the act strikes me as odd, because the 2002 amendment says that in order to avoid blocking of Slovakia's owned deposits, which was a 25 to 30% occurrence before that amendment. In 2005 to 6, this blocking dropped down to 4 to 5% due to other reasons other than inactivity of companies, because all who were not excavating were tendered for these particular mining areas. Not a single case was the case that selection committee selecting the winner would abolish or change, or court would abolish or change decision of selection committee.
I understood paragraph 8 at the end yourself saying that those who are trying to block the deposits, or some that could have waited for better market conditions to commence activities, or to transfer the areas to other interested party, others were unable to finance the actual mining activities. But anyways, I'll move on to the next issue in that document, which is document with the company submitted. Here there's an allegation of one of the 5 losing bidders saying that the winner didn't submit anything other than a document that is worth 0, that is not a commitment, but only a commitment to negotiate. And I would assume that when you have a company like this that wins, following the revocation of somebody's rights, upon receipt of a very reputable company's letter saying these guys are phony, they have no means, to verify whether that is true or not, in the interest of the legitimacy of the process, but also in the interest of the public, to ensure that that company didn't just provide the document that Mondo is describing. So the question again is, did you verify whether Mondo Minerals' allegation is correct or not? No, you didn't.
máte za
Do you have in mind that the reputable company whose Representative Keller discussed with Minister Rusko, this Mondo Minerals or Mondo Minerals Slovakia. Because in case of Mondo Minerals Slovakia, and a legal representative at the time of submitting the complaint, we have thoroughly investigated the complaint, and we had responded in writing. And the party was happy with our reply to the complaint because they have not used any recourse with the court.
And the response, I understand it, that following this letter, there was a committee put in place, and the result of it is R0194, namely the document previously where I wrote, and the answer was simply that, not that this agency had the means,
Pardon.
it's not trade activity, and it has the financial means that we verified, but the 5 others were excluded. R0194, dated September 6, 2005, I understand is in response to the complaint precisely of Mondo Minerals.
Máme na...
Are we talking about the minutes of the advisory committee from 6th September 2005?
To nie je odpoveď.
This is not the official reply to the complaint by Mondo Minerals.
I'll read the statement of defense. I represent what I'm reading to you is a statement of defense of your lawyers of Slovakia. At paragraph 310, they say, following the selection of Economy Agency as the winning bidder, a company named Mondo Minerals Slovakia challenged the selection procedure. As a response to this challenge, the main mining office composed an advisory committee to evaluate the selection procedure as a whole. After thorough review of the bids, the advisory committee issued its written conclusions on September 6, 2005, and it points to this document. Okay? So is it correct, is what I just read from your lawyer's representation, that the Mondo complaint led to the document of 6th of September 2005?
Ja nehovorím o tom, čo povedali právni zastupcovia.
I'm not commenting on the statements of my legal counsel. I am not questioning their statement. What I am saying is that this record is not the official reply to Mondo Minerals. The reply needs to have needs to comply with certain forms. I am not saying that certain parts of the text were not taken from this document, but this is not the reply to Mondo Minerals per se from the main mining office. This is an internal document. And the document which lists, or which is a record of the meeting when we were investigating the complaints that were raised. The official reply needs to have the official heading, main mining office, and at the end it needs to be signed by the head of the main mining office, which I'm sure you're perfectly aware of.
Then you mentioned that the project carried on, and there was a...
I have a question relating to the previous exhibit, which is the complaint by Mondo Minerals. If you go to the 3rd page, that's under tab 36. I don't know. 3rd page, 2nd paragraph, the page which starts with 7, with the number 7 at the top. One of the complaints is that the application submitted into the selection procedure should have fulfilled, among other things, well, the fact that an application must be accompanied by a relevant mining authorization. And apparently the winner didn't have it. I mean, that's what is implied in the letter of Mondo Minerals. So did it have that authorization, the general permit to conduct mining activities? Did it have it? And if not, is it wrong? And if it had it, how could it have it?
Môžem, pán predseda?
May I reply?
Prosím.
Well, certainly, at an RV agency, when we talk about the permit, they definitely had to have this permit, this authorization, before even submitting their bid for the tender. Otherwise, their proposal or their bid would not be accepted. This information in the complaint by Mondo Minerals, the fact that they claimed that the RV agency had no authorization for mining activity, this is not based on true. It's not substantiated. I'm perfectly informed about this.
Can you explain? They had that authorization?
Samozrejme.
Yes, quite clearly, they had the authorization. One of the conditions in order for an organization to be accepted when applying for such a tender procedure, when we are allocating a mining area or extraction area to another mining company, there are also other possibilities how you can acquire an extraction area. Well, the basic precondition is quite clearly for the organization to be to have a license which enables them to operate in this economic activity. In case of Slovak territory, if you perform mining activity, it is the mining authorization. Mining authorization can be obtained only by a Slovak legal entity which employs a professional expert who is professionally authorized to guarantee the professional administration and guidance of mining activity.
Takéhoto projektu.
If they employ such an individual, this chief of mine or this chief of quarry, then the respective district mining office issues such a permit, such an authorization. From all the applicants, all of them had this authorization. Otherwise, they would not be part of the tender.
I think the following paragraph makes clear that it's two other companies, Nuco Slovakia and IMI Fabi, that are the ones that didn't have that permit. It did not relate to Economy Agency, which would be consistent with the testimony just given.
Okay, thank you. So they had the authorization, that's what you say. Okay, thank you. Well, still, to get the authorization, isn't there a procedure which takes some time? And can you explain, maybe, because I understand that was a new company? So.
Áno.
Yes. Well, the procedure is as follows. I'm sure this is not that complicated and it will not surprise you. The basic preconditions are outlined in the Mining Act 51 from in the paragraphs, and the gentleman quotes the respective parts of the law. This mining authorization, or this process of issuing the mining authorization follows the administrative law for the Slovak Republic. This is the administrative order. This is 71 from the year 1967. According to this procedural document, the district mining office has to control all the respective formal attributes of the applications which are listed in the in Act number 51. What everything has to accompany such an application. In general, first of all, they have to issue the valid print or valid confirmation about their registration with as a legal entity in Slovakia, not older than 3 months. Then they have to also confirm that they have paid the administrative fee. And thirdly, they need to verify who is the expert authority if this is not the respective representative of the company. They also have to issue the certificate of evidence from the criminal registry of Slovakia. If they issue all these documents and everything is confirmed, and on the basis of this application, the administrative procedure is concluded and the authorization for mining activity is issued. No other meeting or another inspection is required. So it is purely administrative procedure. We do not take into consideration the size or any other attributes of the company. So if you comply with these requirements, we have no other choice but to issue such an authorization. The whole period stipulated by the law has to be processed within 30 days. So at the latest within 30 days of lodging such an application. It is a license which is issued by a declaratory statement of the state administration. In this case, it is the DMO, after confirming or after verifying all the attributes, all the particulars.
I suppose that it's the presence of Mr. Chore which decided the DMO to grant this permit. The presence of Mr. Chore in the company or as a husband of the manager?
Prepáčte, pán predseda, neviem, akú prítomnosť.
Apologies. I don't know, Mr. Chairman, what do you mean under the presence of Mr. Chore? Mr. Chore is quite clearly a legitimate expert who has received his authorization long time before. 15, 20 years ago, he has been authorized as a mining expert. He's officially and registered as a mining expert. In my understanding, he is very known to all the expert bodies. He's quite notorious as a member of our chamber, as an active member of our mining community. Equally,
That's precisely why I was supposing that the reason why the company got the permit was his presence.
No, ja si myslím, že dôvod.
well, I think that the reason was the fact that this was the fact that Mr. Chore owns this official certificate, but not that his name is Chore. The fact that he is officially authorized was the main precondition.
Of course, I was not meaning that it was because of his name, which could be any name. Thank you.
Ospravedlňujem sa, ten.
My apologies. Perhaps there are some issues in interpreting. I meant that I thought that you are alluding to the fact that he was himself. No, the district mining office cannot discriminate against anyone or cannot support anyone or cannot give priority to anyone because we control it by a second instance and we would simply identify.
I was simply alluding to the fact that he was precisely someone as you described. Now, sorry, Mr. Yes,
thank you, President. You know, how is this? How serious is this tender process after revocation? Because I see this economy agency registered newly under the name of an accountant. Could have the shareholders of Roseman, after the revocation, set up a company, called it I don't know, very economic agency or Rockefeller agency, and then applied. Would they have been allowed to apply as shareholders of another company?
Ako iný subjekt, áno.
Well, yes, as another legal entity, yes. The Slovak administrative law enables that.
Oops. It's his fault. I apologize. But then how could it be? Because you kick out people, a company is kicked out because its shareholders are unable to process, and these same shareholders tomorrow set up a company and apply again for the same deposit. How is that rational?
I do not understand who is supposed to justify anything to whom.
Tu nie je možné, aby jeden
It is not possible for one owner to have several companies, is it not? It's a matter of holding the excavation area, tie that to specific entity, having specific company registration number, which is tied then in turn to specific rights and obligations. Rosmin, by its own inactivity, without any third party's fault, had caused themselves, by themselves, the cessation of their rights to mine in that area. That is not tied to ownership, to any professional aptitude, which means, if I were to understand this correctly, though professionally licensed person may no longer operate or exist. They did have the right. They could do it. Why they did not do it, I don't know. Rosmin is not obliged to justify this to us, and Rosmin had other options they could have explored how to resolve their problem, and despite that, they did not do so.
You know, the issue that I also have with all this is that economy agency, which this is our submission, did not have any means nor intention to go forward with the project, was selected in the circumstances that we described, and then 6 months, 9 months later, gave all of his shares, merged with another company. And it's the other company that moved the project forward. So basically, it was a broker there. Just got something.
Chcete povedať, že tak ako firma Rosmin?
Do you want to say just like Rosmin?
Viem, čo v podstate na to povedať iné ako takéto.
I don't know what to say else but this. The entire procedure of the entire administrative proceedings aiming at handing over the excavation area to another company, the entire tender procedure when the independent selection committee was selecting from amongst the bidders the winner, and no other entity may enter the powers of this particular selection commission. It was verified twice by Regional Prosecution Office, by Criminal Police of Slovakia, and twice by Judicial Review. Neither one of these bodies had come to the conclusion that with these steps of either the selection committee or DMO or MMO, there would be any violation as to the substantive matter at hand, and all the other small shortcomings identified in complaints were subsequently removed. And Rosmin did not use any extraordinary recourse they had available throughout the period of 3 years, 3 times.
I think, I don't know if you have probably many problems with me, but the problem I had with you during the last hours is that everything I ask you to justify, you say, oh, there was a procedure in place, everything was correct, was verified. But that's not what all this is about. If it is as simple as that, there would be no purpose of questions and answers. So I try again on this point. Doesn't it bother you, the fact that somebody was kicked out, it was given to a company owned by an accountant in the circumstances we described, and that company finally, it's not that company that provided the means, that moved forward the project, and went on and found another who moved then the project forward. That doesn't bother you?
You know, first of all, I don't have any problem with you. I just said a moment ago that I consider you a very smart lawyer. I mean it seriously. The one thing I have a problem with is that you're wanting me to answer something, to speak on behalf of the selection commission. Based on what legal title am I to judge the proceedings made by selection commission having done their job based on their best conscience and knowledge back in 2005? I don't know what consideration the selection commission was taking into account. I don't know each one member of the commission when they are voting in secret, how they establish in their own minds the order of the bidders. And this envelope, it still remains unsealed until this very day. Neither prosecution, nor criminal police, nor the Supreme Court had opened the envelope. You know why? Because they have all found that it's a decision of a collective body which needs to be respected. Because if it's not going to be respected, such decision of collective body composed of independent entities, there will be anarchy. Neither DMO nor MMO, please do kindly take this into consideration, did not judge this. It was judged by commission, selection commission. It was established by law, by the parliament. It was put into the legislation, forgive me, by the parliament. The only thing I can admit is the fact that the legislator did not put into the legislation, the 558, those procedural provisions which, even after experience of having with those selection commissions, were available by Amendment 219 of 2007. If we were to have had these procedural provisions at that time in the law, then the court would not be able to find so many shortcomings they have found, because they have not found them subsequently with the final decision of the Supreme Court. And all remedies were available at any time.
Then you are my professor, because you did it again to me. I asked you a clear, specific question, and you went out. I don't know where you went out, but you did that throughout. So I returned the compliment. Now, the things you said, there are a number of things you said that I have issues with, but I will just pick on one. I'm saying it's not true. It's not true, sir, that when the tender applicants submitted their application, it was not opened. Because we know, and we have alleged, that there is a document showing that somebody from the district office not only opened it, but engaged in commenting on these tenders. Do you have anything to say to that?
Only that I'm not aware of any commenting.
Interested to find out about that.
V čase,
Of course, sorry. At the time of the tender, I don't know how else to respond to this. At the time of the tender, at the time when these matters were published in the commercial journal, business journal, and when it was notified to organization that their rights have ceased, and what you're describing here, there was some discussions held amongst some entities. I'm not aware of any of that. I've never seen Mr. Keller. I don't know him. I've never met him. I don't know who's the representative of IMIFABA or whatever other entity. That which I do know, I can say that I would never allow myself to say something untrue. I'm not here in the capacity of a private person. I'm here as a representative of a state body.
Have within the contents of this procedure, you should have at the time when you were reviewing all these documents, because that thing is very material. And we invite you to do so in the future. That document exists and your counsel has it. In any event, my last question is that your submission is that there were 50 other companies whose licenses were revoked in the same circumstances as ours.
That was not his testimony.
I'm asking the gentleman whether I'm asking him, is that was his testimony?
No, you represented to him that his testimony was that there were 50 other companies.
How
He
many
never-
other companies? Because in your witness statement, you mentioned a number of companies whose licenses were revoked in the same circumstances.
približne 30.
Approximately 30.
30. Could you give him my phone number? Further questions?
Ja by som poprosil, keď mám dať
May I, if I were to give him phone number, give me your business cards.
Redirect.
I do have some. In fact, on that topic, you did indicate, Mr. Kukelchik, that there were approximately 30 other reassignment or cancellation procedures in 2005, which was, of course, the same year when the Rosman excavation area was reassigned. Out of those procedures, how many of them, just approximately, actually led to the cancellation or reassignment of the excavation area.
Vo všet...
In all cases.
Thank you. And of those, besides Rosman, how many of them appealed the decision up to the Supreme Court complaining that the law was unclear?
Najvyšší súd
The Supreme Court only handled one such case.
So Rosman, out of all of these other companies who went through a similar procedure, was the only one that complained to the Supreme Court that the law was unclear.
v
In 2002 to 2005, yes. Sorry, 2007. I mistook the year.
Now, you had tested...
Pardon, boli tam ešte...
Apologies. I wanted to say I got taken aback by the wrong year. There were 3 or 4 additional complaints made to the regional prosecution office. For the procedural matter, they were all stating that the district mining office did not violate any act, and it never went up to a higher instance, even to the MMO.
Thank you. Now, you had testified at some length about the purpose behind the 2002 amendment. Is it your opinion that the 2002 amendment was successful in reducing the number of companies that idly sat on excavation areas?
Určite.
Definitely.
Je to úplne jasné zo
It is completely clear from the statistical data from the fees collected for areas mined.
I would object in the future to leading questions. Was the thing successful? It calls for an answer, which is yes.
You had, in answering Mr. Garavi's questions, I think mentioned a celebration or some type of gathering within the mining community sometime in May 2004 when Mr. Rozložník had approached you and there was some discussion about the 2004 amendment. Mr. Garavi didn't let you finish that answer. I'd like to give you the opportunity to do so now.
A simple answer, it was not in May 2004, but it was in the second Thursday and second Friday of September 2004, as part of the Slovak-wide celebrations of the Day of the Miners, when I personally have, with good intentions, briefed Mr. Rozložník, whom I know very well as a man who's very capable and responsible person in Rozmin, that there is an amendment in place and that there is a risk which could occur, such problems could occur, when there is an obligatory proceedings by law or by the DMO. And he gave me a friendly answer. I'm aware of this and we will be paying attention to that.
Once a company has failed to commence excavation within the 3-year time period, under Slovak law, is it your understanding that that company can participate in the tender to try to win back the excavation area?
The Mining Act says clearly it will be transferred to another organization due to inactivity. So the same company may not bid in a tender for the same mining area. Selection Commission would have to respect that stipulation by law.
I think I have only one final question for you, Mr. Kukelchik. Do you know whether the successor to Economic Agency opened the mine in accordance with the Economic Agency project plan, the technical solution that they had proposed in their bid?
Yes, it is so. They've opened in accordance with the project submitted and within the deadline prescribed by law. I know it exactly because we were submitting this evidence to the court as part of our administrative file.
Fair to say then that Just, I think, rephrasing the answer you just gave, the technical solution that was proposed by Mr. Chore's company in the bid with the economy agency ultimately proved successful.
That's leading, sir. It's a textbook leading question.
I'll withdraw the question. I have nothing further, Mr. Chairman.
Thank you. So this completes your examination. Thank you very much for coming here. Now we'll have a 15 minutes break before the examination of Mr. Chore.
Ďakujem, pán predseda.
Good afternoon, Mr. Chore. You are appearing as a witness in this case, called by respondent. You have a statement in front of you. Can you please read it aloud?
Vyhlásenie svedka. Slávnostne
Witness statement. I solemnly swear an oath to saying the truth, nothing but the truth, and the whole truth.
Direct examination.
Just very brief. Good afternoon, Mr. Chore. Mr. Chore, are you an employee of the Slovak state?
Nie som zamestnancom.
No, I am not employee of the Slovak Republic.
And are you here today representing the Slovak state?
No.
Then it may be helpful if you could tell the tribunal why you are here today testifying.
I'm here as a witness because legal counsel on behalf of Slovak Republic had approached me in relation to the undergoing dispute between Slovakia and EuroGas or Belmont, Slovak Republic, where they asked me to several questions, whether I'd be willing to answer those questions, which I did, and based on that, my testimony as a witness was drafted, which is part of the file here, submitted.
And are you being reimbursed by the Slovak Republic for your lost time and expenses for your work in this arbitration?
Zo strany Slovenskej republiky.
I'm not sure how it works elsewhere, but there are some legal standards applicable in Slovakia which stipulate exactly how I get reimbursed for expenditures related to my witness testimony for individual witnesses.
And is it your understanding that the reimbursement the Slovak Republic is providing you for your lost time and expenses is consistent with the Slovak legislation on reimbursement of witnesses?
Áno.
Yes.
I have nothing further, Mr. Chairman.
Thank you. Cross-examination by Mr. Garavi.
Good afternoon, sir. I'm counsel for Belmont, and I'm going to put some questions to you. I kindly invite you to look at your first statement, witness statement. Paragraph 41, you say payments from Rosman were always late. And that's in relation to the time when you were a shareholder and a contractor of Rosman in 2001. And then you go on. Even in the above paragraph at the end of 39, you say Rosman were always late. Then at paragraph 44, you say, in the middle of it, starting by Rima Morin, was getting into bigger and bigger financial problems. We did not have many money to pay for the works at the deposit we owed to our suppliers, and we were under a threat of bankruptcy. When you say here we were under the threat of bankruptcy, you mean Rima Morin, right? Not, it's Rima Morin that was under.
Yes.
You get, it seems that you become bankrupt quite easily, sir, because the amounts you're setting out are not significant amounts, are they?
The amounts were substantial for such company and for such demanding mining works and mining project we opened.
At the period you described, for example, in April, May, and June, let's take May 2001.
It had stayed at the figure 5,086,000 Slovak crowns.
That's in May 2001?
Presne citujem 5
Let me quote exactly: 5,060,812 Slovak crowns. It's 168,000 euros and some small change. That was the debt of the company. Rosmin to Rimamuran.
I mean, that's not a very significant amount, is it? To become bankrupt? I
Keď sa
mean,
vrátime do rokov
Going back to roughly 2000, it was at the time, for such companies in Slovakia in general, it was a substantial amount. 5 million crowns was, at that time, a big money. It was not a small amount. One realizes that the entire project we were to implement had cost 71 million crowns.
kindly go to tab 18 of the first bundle, which is R0169. It's a letter from Rosman, dated July 25th, 2001, R0169. It's sent by Dr. Rozloznik to you, I believe. Was it sent to you at the time?
bol zaslaný
It was sent to a company Rimamuran.
Okay, but you reviewed it at the time, correct?
no rozhodne.
Yes, definitely.
Okay, you agree with the conclusions that are set out here? It says that there's a table on the
Nie,
back.
nesúhlasím.
No, I disagree.
What items of it you disagree with?
So záverom a
With the conclusion and with the amount. Mainly with the amount, because the figure here is definitely the one I mentioned earlier, which is 5,060,000 crowns. And it was further confirmed later, because when there was settlement had occurred of some problematic issues between the two companies, the company, I think it was EuroGas at that time, had acknowledged this amount and paid the due amount in this figure.
Of time, sir. I'm not going forward. To facilitate that, I propose that you keep that document open and you look at your response dated July 23rd, 2001. It is in the pochette R0126, should be the first document. And in that letter, you, in response to R0169, you say the line that you find for HV line should be removed, but it has been paid, so I guess that amount is neutralized. Then you have an issue only with the payment received in relation to your invoice of 6 million crowns that is on the table, right-hand table of page 29 of R0169. And my understanding, you say out of that 6 million amount, I didn't receive the 3,748,000 indicated in the letter of Rosman, but only 2,159,000. Is my understanding correct?
Toto si už presne
I don't remember this exactly, I have to admit, that because these things were mainly related to the economy of our company, which was the economy's department responsibility. I was in charge of technical implementation of the work and technical supervision over the implementation. So please do not take me precisely with regard to specific figures. And given the time that has lapsed since, I'm not able to recall exact figures.
stále
I insist, and we have always required payments due from Rosmin in the amount of 5,086,000 and change, which later was accepted and paid. So these tables I do not take as fully relevant, and even later on I cannot really respond to those tables anymore.
I didn't invite you to submit a witness statement. Slovak Republic did. And in your witness statement, you indicate precise dates. April, May, June, July. And then you draw a conclusion, or at least an implied conclusion, that it was Rosmin that caused the financial difficulties that your company was undergoing at the time. I point out to a letter at the time that was sent to you and the response you provided under your signature. And the conclusion I draw from that is that you contest only the 6 million invoice in the table, and you said you didn't receive 3,748,000, but you received only 2,159,000, which makes it that you have a shortfall of only 3,900,000, which is not much, I suggest. And moreover, it relates, if you look at the table at R016, it's advanced payment invoices submitted by Ruma Murin and yet not covered by actual work carried out. And then if you add to it the amounts also received for your previous invoices, 1,400,000, 1,000,000 for advanced payments, whereas work was not carried out, and the advance payment set out on the next table, which means of 2,073,000, that you are cash positive.
nie je to vôbec pravda.
This is not true at all, because in reality, the situation was as I've already described it to you. Rosmin was not paying on regular basis, and as a result of that, we've becoming insolvent.
Your word, right? That's your word, that's your testimony. I point out to a document that Rosmin wrote at the time and a letter that you signed.
Mr. Garawi, just to be sure I'm not, I'm following. R0169, it said it's a letter from Rima Muran to Rosmin, but I guess it's a letter from Rosmin to Rima Muran, unless I don't understand
Yes,
things correctly.
this is a letter from...
So it's wrong.
No, that you should have found in the... Okay, yes, yes,
Okay,
yes.
so
Yes.
I was just sure to be following.
Yeah. Non, ça c'est juste.
169 is not...
Oh, yes, 169, it's from Rosmin to Rima Muran, and the R0126, I apologize, is from Rima Muran to Rosmin. Yes, so you see, Mr. Courage, you come here, a number of years after a dispute that relates to my client in the Slovak Republic, and you bring in your personal issues with Rosmin. You make certain allegations that discredit my client. I put to you two documents, one signed by Rosmin to you, and the other in response, that both of them put together showed that you were cash positive at a period of time where you allege in your first witness statement that my client was in payment default, and moreover that that was causing the insolvency of your company for a very ridiculous amount. So what do you have to say to that? Apart from that, I don't remember.
I'll read in detail the letter I wrote. On 22nd May 2001, there was a general meeting held of Rosmin. At this general meeting, among other things, we've discussed this status of funding of work at Gemerská Poloma. Advance payment was approved in the amount of 6 million crowns. See section 4 of the minutes of the general meeting. The amount has not been paid to date. 3.748 million Slovak crowns were paid out of that amount, as the last installment was paid on 12 July 2001 in the amount of 1.885 million. Under sections 14 and 15 of the contract for works, the contractor is authorized to suspend works in case the customer fails to pay a partial invoice. As of the work suspension date, it has been 62 calendar days. We suspended the works on the basis of that fact. As to submitted invoices for work actually carried out and payment of those invoices, we have to notify you that the provided amounts for high voltage line cannot be included in other invoices because a separate contract was concluded for that line. The invoices provided in a table cannot be correct because as of 1st July 2001, out of 6 million crowns was only 2.159, 500,000 was paid. The other matters will be handled by taking over the works for April, May, June, and July. Surface construction July and underground works. We request that you provide us with funds for further continuation of works. So I did not make this up just now, that there was no funding available, clearly for us to be able to continue our work. Bills were not paid, invoices were not paid for material. And the worst situation occurred in the case at this general meeting, even though it was promised by the EuroGas executive officer or CEO that amount would be paid in the amount of 6 million total. It was never paid in full. And due to that, or as a result of that, we would gradually be fading out or phasing out our works until full suspension of our works. So I do insist on the fact that the owing amount of Rosmin, final amount towards Rima Muraň, is the 5.08 and change million crowns, which personally was approved, acknowledged by EuroGas representatives by signing a settlement agreement where this amount was acknowledged by them and later paid in shareholdings 40%, which we handed over to the company EuroGas as the counter value, 43% shareholding of Rima Muraň. I have nothing more to add to that.
Okay, but I just repeat my understanding of these documents is that you were cash positive because the only outstanding invoice at the time was an invoice for works not yet carried out, and moreover largely compensated for other amounts received for works not carried out, plus the advance payment you received. So I just don't understand how we could have caused your bankruptcy, because these, you were advanced cash positive, and moreover for works that you have not carried out.
Musím vás veľmi...
I have to correct you very much. All works during that period with regard to surface construction has been completed and they were handed over. We are discussing now 2001. In 2001, in spring, the main ramp began to be drilled. meaning that all surface structures had to be completed by then. So claiming that we have not completed some of the surface structures is completely unacceptable. They were all completed as it was stipulated by the letter on processing costs per individual structures, above surface structures. So I cannot agree with you that we would not have completed some of our above surface structures. They were all completed as defined in the tender terms of reference defined by Rosmin themselves. One exception, perhaps, would be the fact that some structures, despite the fact that they were...
I'm not talking about a construction dispute. I'm just talking about your cash position and the impact. And I think we covered it. And the other question I have for you, sir, is that would you agree with me that there was a dispute also between the parties at the time about the quality of the work? Now, I have no intention, before you answer, to engage with you as to who is right or wrong. I don't want to get into a construction dispute. But do you agree that at the time there was a debate as to the quality of the work your company was providing? Yes or no?
No.
Trvám na tom,
I do insist that all works done by us were fully in line with the project documentation, and I can substantiate that with the fact that I have summoned the Rudny project, the design office who produced the design, and they have documented and conducted an authorship supervision over the site, and they have made a record of the inspection they have conducted, claiming that all the works have been completed in accordance with the design.
I'm not saying to you who's right or wrong. I'm not asking you this. I'm asking you whether or not, rightly or wrongly, Rosman was claiming at the time that the quality of the works you were providing was not good, was bad. Was Rosman claiming that the works you were doing were bad at the time?
čo sa týka
With regard to the above surface structures, no. They only had one single reservation against the mining office. Apologies, interpreter, not office, the mining works.
May I deduct from your previous answer, since you commissioned the work to verify or not whether your works were good, that means there was an allegation by Rosman that the works were not good. Can I conclude that and move on to my next question?
It cannot be understood as that, because also the organization, the company Rima Muran, having performed this work, did have their own authorized supervision with regard to the above surface structures. It was not necessary for mining work because the supervision was conducted by myself in person, and from the side of Rosmin for above surface structures, I'm not sure who conducted the supervision there, but for mining work they had a gentleman conducting supervision. I keep insisting that the only, from their side, declared problem was the decline of the mining works, and it's a very simple problem.
There were problems. And the question I have now...
neboli
is that-
ťažkosti, preto
There were no problems because those problems did not pertain at all to Rosmin as a company.
agree that Rosman was also claiming that your company was going over budget. And again, I don't want an answer, but there were additional works and a justification. Were there claims made by Rosman at the time that your company was going over budget? Just a yes or no question.
Yes, but one thing needs to be explained. Substantial fact. I have to explain one substantial fact.
Not interested in, I don't want to defend the position of Roseman. I'm just trying to find out whether or not there was a claim on their side. And maybe if you think that is relevant, counsel for respondent will allow you to elaborate. May I also, would you suggest that you agree with me that some of the shareholders of Roseman had issues with you in your capacity as a shareholder?
Neviem, čo máte komunikovať.
I don't know what exactly you have in mind.
Were you in dispute with Mr. Robal or other shareholders at the time in your capacity as a shareholder? Not as a contractor. Forget about contractor.
Mali sme jeden
We did have one problem, yes.
Then, may I also suggest that your exit from Roseman was a sour exit? That you perceived it at the time as being a very sour experience? Again, rightly or wrongly. It was not good, huh?
odchod.
Leaving whom? Who from where? You mean my person or?
When I read your statement and when I see your presence here, I understand, maybe rightly so, that you were upset because you are claiming, moreover, that it caused you bankruptcy, you didn't sell in good conditions. And I'm just asking you whether that's a fair conclusion to draw from your testimony, that all this left a sour taste in your mouth.
Certainly. It was difficult for me to say goodbye to that project because I dedicated some 20 years of my professional life to that. So it's not simple to leave such project, and even under such circumstances.
I'm not challenging whether you were right or not. And if I move now to paragraph, I would say 50, 54 of your first witness statement, you say, according to my knowledge, and here you are talking about the year 2004, you say no further works were performed at the deposit until the moment when Siderit came to deposit in 2004. And you said, I personally notified representatives of Siderit to be aware of finances and to always ask an advance payment and not to perform any work unless they are first paid. I mean, why are you going out of your way in relation to a project that you left years ago? First, to follow up the project, and two, to write to our contractor to discredit us. I mean, here in this arbitration, I understand it's Slovak Republic that contacts you, but back then, why are you following up and why are you trying to discredit us?
Jedna vec,
One thing, the project Gemerská Poloma was, is, and shall remain my issue close to my heart. That's as a side comment. As per your question, with regard to Siderit, not myself have contacted Siderit, but it was the other way around. Siderit contacted me, asking me what kind of people are these with whom they are to go into some kind of business. I only told them the truth, what experience our company had with them, and nothing going out of my way. I told them.
If I understand you correctly, paragraph 54 was that I personally notified representatives of Siderit in response to their inquiry, correct? Because you say they contacted you to be aware of finances. You received a call basically from Siderit. So they contacted you,
áno,
right?
Yes,
Okay, you didn't mention that in paragraph 54. You forgot, I guess. But you didn't find that necessary.
Keby sme chceli rozprávať o celej histórii,
If we would debate over the entire history of this problem, we would need much more time for that.
A very direct and simple question. They approached you to ask comments about the financial strength of Rosmin. You didn't approach them, correct?
no určite nie ich.
Definitely not me, them. And I had major reasons for that.
Approached them. Who approached you and when the first time from Siderit?
Just to make one thing clear,
Who approached you from Siderit and when? Can you give me a name and an approximate date?
it was Mr. Bolacek, who at that time performed the job of an economist of the company.
What month, do you remember?
No, tak to bolo.
It was in 2004, for sure.
First half, second half of 2004?
To už ma nechytáte za slovo, pretože
Please do not catch me for my word because I no longer recall that precise information.
During one of the 365 days of that year, right? That's how I should understand it. Did he contact you in writing, by phone, by email?
nie, stretli sme sa niekde.
No, we met somewhere, some social occasion. I don't know exactly how it was, but we just debated in person on this topic, and he told me that they were approached to join this venture, and he asked me, they wanted to know from me with whom, what, and under what conditions. Simply, they were asking about more details about the projects, knowing that I had much more details available, which they did not.
Okay, now that you know there was a social occasion, do you remember which social occasion and approximately when in that year? It's a meeting you had. You remember it to a point to put it in writing in a testimony.
Viete, to je tak, že ja som sa s nimi stretával.
I was meeting these people basically every other day. So please do not ask me to. Even my neighbors, some of them. Director of Nižné Slané Oravec is my neighbor. Bolacek was another neighbor. Bernard was another neighbor, just like Mihok. So I would meet these people at regular basis, quite frequently. So we would discuss this topic on more occasions, but officially, mainly, I debated this with the gentleman I already mentioned.
Then you don't recall at which social occasion. And I'll move on. If you don't remember, you don't remember.
I'm unable to answer what occasion it was because there were many such occasions.
Okay, here you made a representation to Siderit about our financial capacities. I understand you warned them from paragraph 54, basically. Why did you write to the government to badmouth us at the time?
No je to. Pretože ma to požiadali.
Because I was asked to provide that information.
You were asked to provide what information? By whom and at what date? Please don't tell me it's a social occasion I don't remember.
Bol to pán inžinier Boláček, ktorý.
It was Mr. Bolacek, who was the economic director of the company Siderit.
No, I apologize. I'm talking about something else now, sir. Let's forget about Siderit. Why did you write to the government of Slovakia in 2004 to badmouth, say bad things about Rosman in 2004?
Neviem, čo máte na mysli.
I don't know what you mean in 2004. What government?
The government of Slovakia, you wrote to them and you badmouthed us, you discredited us.
Neviem,
I don't know what you have in mind.
Mr. Chairman, I think there's a foundation that has to be laid here first, that such a letter was written, the date of the letter, and we can move on from there, but
Well-
we seem to have skipped a step.
That's right.
Sir, did you write or not in 2004 to any organ of the Slovak Republic to discredit Roseman in relation to the stock deposit?
nepamätám sa.
I don't remember.
Myslím si, že skôr nie.
But I think more likely not.